be substantial sureties. The sureties are found substantial. All the three sureties presented are found substantial in this matter. For reasons that the accused person pleaded not guilty, is presumed innocent, he has presented three sureties that this court has found substantial. This court is of the view that the accused person be granted bail, as I hereby do. The accused person is granted bail. But these are the terms. He's granted bail on the following terms. He's going to execute a cash bond of 500,000 Ugandan shillings. The accused shall execute a cash bond of 500,000 Ugandan shillings. Each of the sureties presented, the ruling that I have made in this application, is the ruling on this application. I have had and taken into account the arguments made for and against this application. The accused person is charged with two bailable offences. He denies the charges, is presumed innocent until he voluntarily pleads guilty to the charges or until he is found guilty by a court of competent jurisdiction. It is this presumption of innocence that gives the accused person a right to apply for bail. But like it has been stated by the state attorney, and it is the position of the law, that to grant or deny of this bail is at the discretion of the court, which discretion court must exercise judiciously, that is to say fairly and reasonably. The state objections relate to the fixed place of abode for the accused person. The argument is that the accused person informed police officers that he is a resident of Chanja, which is in Nakawa division, and the introduction letter that he has presented through his lawyers today shows that he is a resident of Lusaka, marking a division. Argument is that these are two totally different divisions. She also objects the first surety for reasons that is a mayor who would be in conflict of interest because he leads both the complainant and the accused, the person. The other objection relates to the third surety being a mere friend, that he may not be in position to execute the duties of the sureties. I have considered the arguments made in rejoinder. The first of all, the requirement of the accused person presenting an introduction letter from the area LC1 where he resides was brought by the bail guidelines, and I want to agree with counsel for the applicant that the framers of these guidelines knew that that information can be found in the charge sheet, but they put this as a requirement. And since the accused person has presented an introduction letter that has not been withdrawn by the author, this court shall take information therein to be the authentic and the place of abode for the accused person. The second objection relates to the second surety, first surety being a mayor. I do not see any conflict of interest here. I do not see any conflict of interest by this witness. The surety presented shall execute a non-cash bond of 5 million. This is non-cash 5 million. This matter is accordingly adjourned to 2nd of October. 2nd of October, and shall be called at 10. 2nd of October at 10 a.m. Thank you. Make sure you deposit your money in the bank. Don't pay anyone else. Bank, because I would want to see that proof of payment.
The following result. Having in mind that the offense with which the accused person is charged with, it is bailable, as stated by the counsel for the accused person. And it is also noted that the bail is not automatic, much as it is bailable. It's at the discretion of the court, either to grant bail or deny bail, that is entirely at the discretion of the Honorable Court. But the discretion is supposed to be exercised judiciously. The court has to take into consideration when granting bail the public interest. Whether the public interest also demands the accused person to release on bail. Counsel talk about the offense with which the accused or applicant is charged with. That is bailable. Yes, it is bailable, but it is also serious in nature. And that one has been read and is known. It is a serious offense which affects actually. It can even affect the entire country. It affects the public. Much as is presumed innocent. We are not condemning that he's already guilty, but that's the fact. The counsel also cited the uncertainty as to when this matter will be tried as one of the grounds that the applicants will be granted bail. Just, I wish to remind the counsel that when the accused person appeared in court, we already informed the court that the inquiries are complete. This matter was not fixed for hearing, basically because we were out of time, and today it was fixed for bail application. Counsel for the accused person tried to apply for bail, but due to time, it was deferred today. That does not mean that the inquiries are incomplete. Prosecution is actually ready to proceed with this matter and have it handled expeditiously. So that one should not be a factor for the applicant to be granted bail. The counsel also stated before the Honorable Court that the applicant has a fixed place of abode. I wish to inform court that this applicant, when he appeared before the police officer, the first thing is to establish his place of residence. And he stated that it's a resident of Chancha, that is in Nakawa division, captured in the charge sheet. And that one was his first full particulars, and also gave his phone contact in regard to that. But today, counsel has come up with another contradicting information in regard to the resident of the applicant, saying that the applicant is a resident of Lusaka village, urban council, in Makindi division, different division now from Nakawa to Makindi. Just I don't know when he shifted, but now he's in Makindi division. So these are not raise issue of doubt as to whether the applicant has fixed place of abode. It is in doubt created by the applicant himself or the lawyer. But the fact remains that applicant's fixed place of abode is in doubt. I pray that court will take into consideration that when granting bail, then the first surety for the applicant is said to be the mayor of this division. A mayor is somebody who owns duty to his subjects, being it the complainant, being it an accused person. The mayor owns duty for them as their mayor. So there is a conflict of interest. Mayor, as a surety, may fail to discharge his obligation because his interest will conflict. He has the complainant who are also his subject. The accused person also is a subject to mayor. Mayor is the head. In local, we even say the mayor is the president of that division. Local people conceive it in that way. So the interest of the mayor will conflict. You can't say, let me support the accused side. About the other one, they are also yours. How will you handle it being the mayor of the division? That's the issue should be taken into consideration. In that circumstance, I pray that the mayor should be found not substantial to sound as security for an accused person. Reason being, he also owns duty for the others who are the side of the complainant. It will conflict. Then the two sureties will be also tendered by the accused person. These are the sureties that this person produced them, but they were just friends. They are friends.
That's it.
So in an event, yes.
As if the second surety is a brother, the one who owns the buying endeavor, if my record serves me well. Right?
Okay. I beg to withdraw that. But the third surety is a friend. Just a friend.
Okay.
As I've mentioned. So in the event, the accused person happened to jump court bail, he may fail to discharge his duty as a surety, which the counsel for the accused person informed this honorable court that they were being taught of their duties as a surety. But to me, he may fail to discharge his duty. Being a friend may not be able to trace the accused person. In the event the accused person runs to the village, how will he trace the accused person? He may fail, just a friend in the city. He will fail. So on that ground, also, and for the interest of justice, it's my humble prayer that this bail is denied, the matter is fixed for hearing, and is handled expeditiously, and his faith is determined. If he is found innocent, find guilty, the faith is determined. I so pray also.
Can you briefly join your worship? We have not contradicted the prosecution as regards whether the inquiries are complete. What we have stated, your worship, is that we are uncertain as regards when the trial will commence. We are also uncertain as regards when this matter will be concluded. Why should he be kept in jail when there is a possibility of him being found to be innocent? And indeed he pleaded not guilty. Your Worship, my land sister for the prosecution has submitted to the effect that there is a contradiction as regards the residence of the applicant before you. But there is a requirement under the bail guidelines that every applicant should have an introduction letter as regards to his residency. The framers of those directions were aware that the prosecution normally indicates on the charge sheet the residence of the accused person. Why would it be required again for one to have an introduction letter? The accused person is at liberty to contradict the findings of the prosecution. Your Worship, on the court record, there is a letter by the local council authority confirming the residence of the accused person. and that residence is within your jurisdiction, Your Worship. Being Lusaka Village in Machinde Division, Kampala. Had we cited the information in the charge sheet, my sister would have objected, saying that they have not produced an introduction letter from local council authority. The information on the charge sheet, Your Worship, is a subject of scrutiny by this court. And that will come at trial, Your Worship. And that is information from the prosecution, not the accused person. Your Worship, the prosecution has as well confirmed that our client is a resident of Machinde. When she raised an objection against the mayor, Ali, being the surety, one of the sureties, saying that he will contradict his interests in regard to the complainant and the accused person, since both are his residents in Machinde Division. That he owes a duty to both. Your Worship, is that a clear indication that the accused person is a resident of Machinde? As regards the mayor having a challenge of contradicting interest, Your Worship, my land sister for the prosecution has not cited any connection between the mayor and the case before you. Is not one of the witnesses or potential witness. And Your Worship, the accused person is still innocent. There is presumption of innocence which he enjoys. Should the mayor be judgmental at this stage that this person is likely be found guilty at this stage. My learned sister is stretching beyond the limits. I invite you to reject that objection. Lastly, Your Worship, my learned sister for the prosecution has stated that a friend being a surety, that he may not execute the duty. That is speculative, Your Worship. There is no proof in that regard, Your Worship. He's saying he's likely, he may not, but that is speculative, Your Worship. And Your Worship, the court should not rely on such baseless objection to deny the accused person bail. Where the law does not define the relationship, which kind of relationship that must exist for one to be a substantial surety. In our practice, Your Worship, friends have been standing as sureties for accused persons. In that regard, Your Worship, I invite you to ignore and reject the objections raised by my learned sister for the prosecution. Grant bail to our client on lenient conditions. Yes, we agree that a bail is not automatic, but Your Worship, the constitutional commandments are clear that when the needful has been done, including presenting substantial sureties, as we have done here, court may exercise its discretionary powers and grant bail. We pray that you invoke your powers as provided for under Section 76 of the Magistrate Courts Act and grant that bail. We so pray, Your Worship.